Welcome to the Policy Committee meeting, June 16th, 2020. Lynn, has the meeting been properly posted?
Yes, we have.
Got it. And there are apparently no citizens here to address us this evening, and we do not have any bright lights, correct?
Correct.
Okay. We have what looks like a long list here tonight. We have 24 policies we're going to be going through, but a number of them are going to be similar because it's just the level that's addressed for. And I am, Joe, are you going to be able to tell us which ones we're going to actually have to take forward, or are there any of these that are going forward? What?
Most of these are legal changes, so
You can
we'll be
keep-
able to handle them at committee.
So we can handle them, you know which ones are not.
Correct. All these items on tonight are action items, so they'll be.
Oh,
action
they all will
items
be
for the
action items here.
committee. Correct. Yes.
Okay, very good.
And then, so they can be discussed, take action on tonight or held off until our July committee meeting, because the policy committee has the ability to approve legal updates without having to go to the board. We just have to give the board the update at that time.
Okay. All right. Well, the first thing we have is the minutes from our previous meeting, which I apparently have missed place. So, that's funny. We have a motion for approval of the minutes from our previous meeting.
I so move.
Moved by Diane,
I'll second, please.
seconded by Corey. Thank you. Any questions or changes to the minutes? Okay. We can do all in favor of here tonight, right? All in favor, please say aye.
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 Opposed? 3-0.
Attention on the,
Yeah. Okay. Now we were going to move into the policies, and as I mentioned, there's a lot of overlap here. We are looking first at policy 1213, 3213, and 4213. The difference between being administrators, staff, and support staff. Correct? And student supervision and welfare. Okay, we have a change on the second page. In all cases, refers us to recognizing the fact that policy 7544 on bullying, wait, is this the one on bullying? No, sorry. This is the one that we should be referring to it beyond this one.
Correct.
We have extracurricular and professional uses only. And then it refers to things like administrators not using pictures, video, memes, and other visual depiction of students that is not pertinent.
So with the proliferation of social media and the essentially the self-marketing that a lot of our schools and teams do, we wanted to put in place language that would allow people to appropriately do it, but also define what would be inappropriate for administrators, teachers, and support staff. So that's what these three policies.
four,
It's the
yeah.
same language in all three policies, but we do have policy groupings for each employee group. So.
it looks like this is one that we looked at last year. 2019 was the last time it was reviewed, and it's just updated, with
Essentially, that's it, yeah.
yeah, just a couple new words to update our social media kind of changes.
Okay, Corey?
It doesn't change the policy, it just defines it further, right, and adds a couple more things. Okay.
It's accurate. And this, now, Joe, do we have to vote on them separately, or can we vote on all three of them as a set?
You can vote on all three policies in one motion, as long as it's moved as such.
Okay. That's what I thought. Anybody want to make a motion for the approval of policies 1213, 3213, and 4213?
Sure.
So moved?
Yes.
So moved by Corey,
I second the motion.
second. Any questions on this one? All in favor of approving policy 1213, the revisions to policy 1213, 3213, and 4213, please say aye. Aye.
Aye.
Opposed? 3-0, Lynn. Okay. Policy 1461, 3161, and 4161, unrequested leaves and absence, fitness for duty. Joe, you want to fill us in on what this one is trying to accomplish?
This clarifies a couple of things. First is the requirement for a medical exam for the unrequested leave of absence and fitness of duty. You can see that in the third paragraph. What would be the fourth paragraph on the page it was struck, it was a little bit more restrictive language. It talked about shall have the medical exam. This now gives some latitude to the superintendent to use their judgment as to, do we need to have the medical exam or not. Also talks about the return to duty, I believe, pending further determination of ability to perform duties, including evaluation of any reasonable accommodations. So this again gets down in, can they come back to work or they can't? And then in this particular policy here, 1461, it talks about what to happen if the superintendent is the administrator in question, and then that gets deferred off to the Board of Education for the appropriate actions pursuant to the policy. So.
And that really is a difference between the first policy and the other two.
Correct. That would be the distinguishing language, because this one does pertain to the superintendent.
And the previous policy didn't allow it was much more specific as to who you could use as a healthcare approver.
Correct. This is more of a mutual discussion. Before it was assigned by the district, and now it is allowed to be the choice of the employee or the choice of the district.
Either or both, yeah.
Correct.
Okay. Questions? Somebody want to move? Diane?
I move that we accept the revisions to policies 1461, 3161, and 4161 on unrequested leaves of absence, fitness of duty as presented.
You?
I'll second, please.
Seconded by Corey. Any other questions or discussion? All in favor, please say aye.
Aye.
Opposed? 0, Lynn. You're going to get a lot of those tonight. Okay. Employee anti-harassment. This one is a little beefier. I think there's some adjustments along the way, too. By the way, I read for a while before I remembered that CO means compliance officer. You probably found that, too. But so if you didn't, that's what the CO is. You're going to see it in there. And Joe, I'll leave it to you to...
Yeah, so this actually addresses protected classes, which is the ADA language for harassment and discrimination investigation. So you see that characteristics has changed to classes.
Right.
And then if you scroll down, this is the reason why your packet is so long, because this is a very lengthy policy. It was developed in coordination with the Office of Civil Rights. It talks about what to happen if the complaint is regarding a compliance officer. So what is the next step? In our case, that Sharon Thede and I are the compliance officers. If there was a complaint alleged against one of us, then what would the process be? And it would go up to the superintendent, and then it would be investigated. And then the other one, the other thing is if the compliance officer or officers were involved in a general decision, even including the superintendent, where a discrimination complaint or harassment complaint was filed, then the process would be then to activate our legal counsel to then conduct the investigation. So those are the real changes to this policy. The first is updating some language. The second is talking about if the complaint is against the compliance officers, and the third is if the compliance officers are unable to conduct the investigation.
And again, I believe the wording is the same.
Across all three
All three
employee
of them.
groups.
This is also a legal one, right? Yeah.
Correct.
Okay. Any questions? Yes.
Ready for motion?
Yes, if you are.
Okay. I move that we accept the revisions as presented for policies 1662, 3362, and 4362 on employee anti-harassment as presented.
Thank you.
I'll second.
Seconded by Corey. Further questions or discussion? Seeing none, all in favor, please say aye.
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 Aye. Opposed? 3-0, Lynn. Okay. We have 3122.01 and 4122.01. And actually, I had a question right up on the front. Joe, on 3122.01, and I guess it's on both of them. When they are referring, in the green ink there, when they are referring to an individual staff member, is that adequate definition of, that is adequate? Okay. So that covers support staff as well as staff?
Yeah, you also have 4122 up, so you do have the policies that cover support staff. So you have
Oh,
staff and
yeah,
support
okay,
staff.
that would make sense now. Thank you.
And really, that statement is the catch-all statement. You see it in, from the Olympics through professional athletics on down the line, that everybody is responsible for what they put in their body. And with the, recent popularity of CBD products and things like that, if people are consuming the wrong CBD product that has THC in it, they can't say, well, I didn't know, or I bought it at. You put it in you, it's your fault. And then that proceeds just to go through, more clearly what the district needs to do as far as putting things into the staff handbook, and then making sure that we are in compliance with federal requirements. And then it outlines what we could do for off-work conduct. And it's of particular importance, I think, for the board and everybody to know that disciplinary action may result from conduct related to drug or alcohol usage, even if it's on the staff member's personal time, if the circumstances create a connection to or nexus with the staff member's role in the district. And there can be situations that happen in the community where a staff member could be in trouble for violating the drug-free workplace, and it could result in disciplinary consequences.
That whole section on the off-work conduct is new.
Correct.
And that'd be the one piece I think that I would have the most, like, staff should be aware of this.
Yep.
Kind of a red flag, per se, as we just kind of just pass it very quietly here at our committee level when we don't have a real big audience or interest. But that's one thing that I think,
The off-work part?
that whole off-work conduct part,
Yeah.
I think should definitely be communicated, that
Yeah, just so the committee knows, two things. One, the staff book acknowledges the handbook every year. So they will see this language added to the handbook. And then after policies are approved, Lynn sends a message to all principals, because principals do that policy in servicing at the beginning of the year, and she informs them that there's been a policy change. So we do communicate it, but there's also the employee's responsibility to know what they can and can't do, and what you could potentially be in trouble for.
And I made a little note to myself under the first green paragraph there, that each staff handbook will include, so that will be added to it now, or is it there now?
Correct. All these HR policies were worked with Sharon Thiede. This is
Okay,
not
she's
in
seen
there-
that's ready.
Correct. This is not in there yet because the committee hasn't approved it, but upon approval, and when she does the revisions for the handbook next year, it will go in there.
Excellent. Further questions on 312201, 412201? Is there a motion for?
I guess this brief discussion.
Oh, sure, please.
It's really, really broad, and I get the idea. I guess my suggestion is this goes in front of the full board. I mean, this is such a big change. If you read this, it tends to provoke public scrutiny, damages staff members' credibility, depict inappropriate involvement of minors. theoretically, this could be a picture of a staff member at a tailgate at a, Packer game. And if they're, I'm trying to do this in my head now, but it's a pretty broad, I don't want to say intrusion, but a pretty broad look into people's personal lives, even if they didn't know if that picture was posted or anything like that. But I'm just one person here, so.
The only thing that I'd add to that is, the language at the beginning, disciplinary action may result from, and I think that allows for some discretion for administration, and then for the board, ultimately, if it's substantial discipline, to tease out the difference between, say, the Packer tailgate party, which somebody's got a beer in their hand and the photograph is taken and posted, versus a party that likens the movie The Hangover, where people would really take things to the extreme and have them posted on social media, and then it would have a negative consequence on the district. So I think that by having the language, instead of shall being there and may being there, there is the discretion for both the board and for administration when applying discipline to someone.
I understand that argument. I guess the counter argument would be, what business did the school board or the school district have in governing people's behavior off work? If it's not criminal activity, if it's not otherwise violating the policy against racial discrimination and all those other things.
And I'm agreeing with you. That's why I mentioned it, because I think that this is a big one to just sneak through here without having a broader look, because I just that unawareness that is now our policy. Since it's new, I think that it goes beyond just the capital letter changes and some of the other things that we're looking at and some of the other earlier policy changes here. This one I kind of tagged right away as being, this one I think we have to take a closer look at.
Sure, we can certainly move that onto the full board and just.
Do that. Okay. I don't have a problem with that. So we will, if we want to move it onto the full board, would we still approve it for removal to the full board then, Joel?
I think that you would, you may want to have a motion to advance it to the board for discussion. That way it's safest, it doesn't get lost then, and Lynn records that in the minutes.
Okay. And I will make that motion then.
Please.
I make the motion to forward policy 3122.01 and 4122.01 on drug-free workplace to the full board for consideration.
Oh, second, please.
Second, any further questions on that? All in favor of moving this to the full board for consideration, please say aye.
Aye.
3-0, Lynn. I'm writing that down, so it's not 3-0 approval. It's it's 3-0 for moving it to the board. Okay. Great. Education licensing. This actually has a title change to it too, so that'll be the new title on it, Lynn? Is that right?
Should be educator licensing.
Yeah. Rather than Wisconsin Quality Educator. Okay. Okay, and Joel?
Yeah, so to remain compliant with PI 34, which is the licensing statute or licensing rule, any teacher employed by the district while holding a Tier 2 license who has fewer than 3 years of full-time teaching experience shall be provided the following. That would be the ongoing orientation and support and a licensed mentor. Right now, licenses are initial educator and then lifetime educator. So there's 2 tiers, I guess, to that licensing. And so for those of us who have been at it for a while, we qualified for the lifetime license. For people who are fresh out of college or brand new to teaching, they would fall into that Tier 2 category. So we would want to support them through their growth and development as a teacher.
And that's basically what they're saying in the green part.
Correct.
Okay.
Just a point of clarification, the licensed mentor would be our building coaches now, as in our current structure?
Could be a building coach, it could be a licensed teacher who would fall into that. It really depends on where you're at and the level of support that you would need. Perhaps a PE teacher who's brand new and needs growth and development would be paired with another PE teacher, because there could be some nuances to the discipline that would be better suited with a veteran PE teacher as a mentor. So, again, Sharon's been through these policies now and has an idea of what needs to be implemented going into next school year.
Okay. Further questions?
Just I guess, two comments. This one has been like since 2011, so this is a major change as far as the Neola kind of little tagline. And one point on the agenda, it says education licensing instead of educator licensing, just to change for.
I already updated it.
Okay. Yep.
Okay, motion?
I'll move to approve the policy changes to policy number 3125, educator licensing, as presented.
I second it.
Thank you. Any further questions, discussion? All in favor, please say aye. Aye.
Aye.
Opposed? 3-0, Lynn. Compensation for part-time staff. Why did I say there was, I wrote a note to myself, wording. What do I see wrong with the wording? Oh, that's all it's changing is the wording. That's what I meant. Okay. Joe? Oh,
Okay.
no definition?
No,
This is it.
It really is some language change to make sure that people are compensated appropriately for what it is that they're doing, not equivalently. So when you start looking at, somebody perhaps who's filling in a 2-hour teaching position, how do we compensate that 2-hour person so that it is appropriate for the work that they're doing, but not necessarily equal to the duties and responsibilities for the full-time?
Okay.
Some balance that goes into the part-time configuration.
It seems like a real clear-cut policy. My only question is that it looks like it's a Neola 2020, so is this brand new language for us?
This is when the update came, so it's not brand new language for us. It's just the updated language.
Oh, just
that
update.
came.
Okay.
So the policy that we had on the book was the lettering that is in black and the strike through
Right.
red, and then the add to it is the underlined green. So it's been on our books.
Okay. So then it's just a matter of speaking to the fraction of a day or fraction of a year kind of a concept
Correct.
as being the way to calculate.
Okay.
I would move that we accept the changes to policies 3410.01 and 4410.01, compensation for part-time staff as presented.
I'll second.
Seconded by Corey. Further questions? All in favor, please say aye. Aye.
Aye.
Opposed? None. 3-0. Leaves of absence. Why did I write it here? The trouble when you read these things, make a note and you can't remember.
We've had the leave of absence policy on our books for a long time. This just clarifies the process that a person would request a voluntary leave of absence, so that the request, will go to the board and it will be approved or could be approved with support of the superintendent. So the process would be recommendation. If the superintendent approves, then the board could approve the absence. If somebody makes the request directly to the board and it's an objection to the superintendent, then we wouldn't be going forward with it.
Okay, and I think that's why I wrote a circle around it with a question mark, because I was trying to figure out the sequence there. So they should be approved by the superintendent in order to even get to the board.
Right.
Okay.
Right. I think it's important to note that a leave of absence is considered 31 days through a full school year. That leave of absences are not things that just carry on forever. There's a defined.
So when they use the term 31 days, is that 31 consecutive days, not school days?
Correct. Unpaid leave of absence by professional staff members for a period of 31 days through a full school year be authorized. I mean, anything that would, FMLA covers other types of leave, For instance, when this goes back now almost 10 years, but when my wife and I had our second child, she requested a 1-year leave of absence to see if we could kind of figure things out financially without her income. And then she had to give notice to the board in the district that she worked in February that she wasn't going to come back, and they had time to approve the position, but it was a 1-year leave, so her position was more or less held for that year.
Okay, any other elements on here? Is there a motion for 34 and,
Say that the only nuance between the two policies is for support staff, the superintendent approves that, not the board. So there is a delineation for support staff and professional staff.
okay.
A lot of that is tied to contractual language and everything else.
I'm sorry, I move to approve policies 3430, 4430, the revisions to those policies regarding leave of absence.
I second it.
Seconded by Diane. Further questions? Seeing none, all in favor, please say aye.
Aye.
Opposed? 3-0, Lynn. And this is employee leaves. This is different than leaves of absence. And Joe, do you want to highlight that difference?
The real change in this talks about leaves for voting, leaves to be an election official, and leaves to testify in court. And it talks about what a person must do and how many days they could get off to perform those duties.
Are those flat out additions to the
Correct. Those are new components to the policy.
components to the leaves policy?
Yep.
Okay, Diane?
Well, and my question was if somebody's subpoenaed to go in and testify, this is H1. If the proceeding relates to a criminal matter under the statutes, the employee may not be discharged from employment for absence due to testifying, provided that the employee provides notice within 1 business day of receiving the subpoena. And that's another thing that is like, I wouldn't know that I'd have to do it the next day. You know, you get the subpoena on Thursday and you need to be reporting it on Friday. That seems harsh. And for the person that would not be normally getting a subpoena to be testifying, to know that that's an expectation.
So from experience, when teachers get subpoenas in the district, I generally get a phone call as to what do I do? Or Sharon Thiede gets a phone call as to how do I record this? It happens right away because it is so shocking. From an operational standpoint, if we don't know within 1 business day that this person does have to testify in court, it makes it very difficult for us to try to find substitute teachers and even plan for the duration of that possible absence. So from that standpoint, it is reasonable to ask for notice within 24 hours because notice is very simple. I mean, it's as simple as using your district email to email human resources or your principal that you have to go to testify that you've been subpoenaed. It's not, the notification process is not a complicated process.
Well, my question would be, how would you receive that notification of subpoena?
It's generally delivered, and I'd ask Corey, he's got a little bit more experience in the
Hand
court,
delivered.
but you're served the papers
Serve
by
the papers.
Sheriff's Department.
So it's not like it'd be in your mailbox and you wouldn't even see it and realize that you missed your 24 hours.
You get it handed to you.
I've never been subpoenaed to have to go testify, so.
Anyone.
You have to provide notice within 1 business day of receiving the subpoena, not within 1 business day of whenever you're supposed to be there.
Right, you get the subpoena and you notify the district. And the subpoena outlines when the trial is going to be taking place. I mean, I've been subpoenaed or been given notice of when trials are, and they're not very detailed documents, but they do give you the time and the date and the location and then the penalties for not showing up. So I've been on the receiving end of this. It's not
Okay.
pretty clear.
It just seemed like a real fast turnaround for the expectation.
Yeah, but it's just a notification to us that it's going to happen in the future. Yeah. Further queries?
I think I'm sorry.
Oh, no, please.
Yeah, as long as this isn't just stuffed in a policy change and the changes that are pointed out to employees, I think it's certainly fine. I'm not suggesting you guys would do that, but I don't know, how do we notify the employees that this is now a change?
So this would be policy that would be reviewed by administration
Right.
with employees at the beginning of the year. This would be covered under any reference in the employee handbook to leaves. where there'd be a cross-reference to the policy that talks about the leaves in the employee handbook. And like I said before, if there is a policy update, Lynn will direct people to what policies have been updated. Now that we've got this whole thing set up on, through board docs, it's much easier for people to access it. And they'll be able to then access through those links what's come up. From a practical standpoint, it is June right now. We still have a number of staff to hire, which usually happens in August. And so, that more meaningful update to all staff will come when Sharon meets face-to-face with new staff or virtually face-to-face with new staff, when principals go over things, and then when they access their employee handbook.
Is there a way to put in the employee handbook a title or a section for subpoenas, receiving a subpoena? Because I don't know if someone who receives a subpoena is going to necessarily know to look at the leave policy.
Good point.
Yeah, that's good.
It seems
that's a
very
good point.
Scott, that,
I will talk to Sharon about what she lists in the employee handbook.
Okay.
And then just to make note of leaves this year, knowing that it is an election year, there is usually a heightened attention to civic duty and such. So people are often questioning, can I be a poll worker? The opportunity to leave school to vote. Do you live in we don't have voting at our schools anymore, so how can I get out during the day to cast my ballot and such, so.
Bill, if I may.
Yes, please.
The leave for voting, again, is new language that I think we'd want to try to bring to people's attention, that there is an unpaid leave available for 3 consecutive hours to be able to get out and vote.
That's coming up here, isn't it? Or is it on here?
That's an F.
Oh, yeah, it's right there. I got a
Yeah, the
circle
leave for
around it in
voting,
fact, yeah.
which again, in an election year would, is I think something that would be noteworthy, that's now part of our policy, that is allowable.
Well, we had, without any policies, the last time around on, was it 2016 or was it in 2018 for something else? Quite a good move in the high schools about getting the 18-year-old kids to vote, including giving them time to do it. I don't remember where that was done, if it was a.
Yeah, there was some discussion at one point about how to help kids get registered to vote.
Right?
Kids' parents, 18-year-olds' parents can give them permission to leave school to cast their vote as an excused absence.
Yeah. And they can register online, so they don't have to go anyplace. Yeah. And there was quite a move generated by some of our kids to get going on it. Particularly vocal at West. And they shot that into you guys. I went over and talked to Christie about it at North, and they were working on it. I don't know what happened south. I guess I might have left that to Benjamin to solve that one. Okay, good. This was interesting. Any further questions on this one?
It's another one that I think, because of the new language there and because it is an election year, I'd almost like to bring it up to the full board to get more recognition than us just kind of passing it through here.
One of the things I was going to say, and you just kind of reminded me, we will be not reviewing, we will be telling the board about these at the next board meeting. So we don't have to have them voting on it again. This is another statutorial one.
Right, I mean, this does, this, just my 2 cents on it. I mean, this could be something that Bill gives in his his update to the board, whereas item number 5, where you wanted the full board to take the vote on it, the drug-free workplace, that could then be a full board vote.
I would be happy to do that.
So, some of these things will come as an update to the board during the policy committee update, if this is not a policy of controversy for anybody.
I think that's do that.
I agree.
More awareness.
Yeah, I agree. Good point.
So
Lynn, could you make a note of that I will be reviewing both of, even though we were voting on this one, I'll be reviewing it with the board at the board meeting, July.
Absolutely, no problem.
Thank you, Lynn. Okay, who's voting? Who's moving?
I can. I'm trying to take some of the the burden here. I had some trouble scrolling, but I wrote them down, so to try to help Diane. I'd move to approve the revisions of policies 3431 and policy 4431, employee leaves as presented.
Thank you.
I second it.
Thank you. Further discussion? Seeing none, all in favor, please say aye. Aye.
Aye.
Opposed? 3-0 on employee leaves. Open enrollment program for inter-district, that is from one district to another district. Joel?
Yeah, this was a statutory change to policy. The first one I would direct you under B1. It talks about how the seat space is determined and what we must declare every January. We go through an extensive process of analyzing where our seats are, and the nice thing, about our district is that we have eAchieve, so essentially we always have space. It may not always be at our brick and mortar locations, but we can allow students to come in and access an education at eAchieve. Other than we go down to point 4, it talks about special education services and if those services are available in the district, and it provides clarifying language on what means to be available or not. So for instance, we have our own occupational therapists, therefore occupational therapy would be available, but there might be circumstances where we have to contract out to meet the needs of one of our resident students. We do not then have to say that we have space in our program based off of that because we're contracting out for somebody else. So if we ever made a determination based off of no space in program, those would be kind of the tests that we would have to make.
I thought it was a good clarification in that context.
Yeah, I had that highlighted for asking you anyway, and you just did it. And on B1, we already do those countings of open spaces, et cetera, and it's like, say, it's not a big issue.
Correct, yeah. Starting in about November, Lynn and Stephanie will begin to crunch the numbers around where our resident enrollment is, and then our resident enrollment plus the kids that we've already accepted under open enrollment and where they're at. Then, as it pertains to special ed, they'll begin to work with Jason Gahan, Karen Peterson, Patty Hobble to review the idea of space and programs, and then we work closely with eAchieve to see where we could allow kids. eAchieve has really been very helpful to us because we've been able to accept many more kids where we may not have space in a face-to-face setting. eAchieve has given us that opportunity then to expand a little bit and provide services if families want it virtually.
My understanding, and I think it's worded in here, is that we do not have open enrollment based on a building, do we?
Correct.
It's
It's not based off, you
district.
can't, correct, you can't open enroll to Waukesha to access Hawthorne. But you can open enroll to the district, and if we have space at Hawthorne, we would place you at Hawthorne.
Okay.
So we will accept, we do our best in January to project where our enrollment will be in August. I mean, you think about how far out and how ridiculous of a process that is. You're trying to make a projection 9 months in advance during cycles of declining enrollment, and now you look at this year with, coronavirus as a, something that we're trying to plan and prepare for going into next year. That January estimate is just an estimate at that. And so when you do get to those decision points, this year they bumped the open enrollment window out. So when you do get to those decision points, you're able to go to a waiting list and accept more and more kids. But you can never be selective with who's on the list. So you can't just say, I'm going to pick kid number 1, 4, 9, 12. If you have 4 seats, you pick numbers 1, 2, 3, 4 when you go to the waiting list. And so, you want to make sure that you do the best you can, and then, fill up your seats as much as appropriate. We talk about this often in January that our hands get tied because you may see as a board that we're recommending that we could take in like 80 fourth graders. And people are like, well, if we can take in 80 fourth graders, can't we do staff reductions? Well, it's 80 fourth graders across 35 sections of fourth grade, and you're talking about maybe 2 kids per classroom. And so, no, you can't get into that in our size of a district. Smaller districts can make different decisions. When you see that you could maybe accept 15 kids, well, those are points where you can condense sections and create some efficiencies. We don't have that ability across our district because we have to offer fourth grade in all of our schools. So.
Okay. Any further questions on this one?
I would move that we accept the changes to policy 5113 on open enrollment program as presented.
I'll second.
Seconded by Corey. Further questions? Seeing none, all in favor of approving that, 5113, say aye.
Aye.
Aye. None opposed? None. Okay. 5,200 attendance, page 3 was. Oh, that's the election day one.
This
I was trying to remember, yeah.
provides the provisions for 16 and 17-year-old students to be excused from school to serve as election officials. Talks about some criteria for attendance, grade point average, and such. So, it gives a kid the opportunity to serve in that election.
Is this a new situation?
The new recommendation: 16 and 17-year-olds are allowed to serve as election officials. We have a policy, though, that talks about what is an excused absence and what is an unexcused absence, and up until this point, being an election official has not been listed in our policy, so we wanted to provide some criteria that would allow a student to do that.
Okay, and it does, and it talks about grade point and a few other situations, okay.
When I first started reading this, I thought it was going to be about the quarantine and some of the other things that are in here. And it's like, oh no, it's this election official piece.
It's the green part.
After we get done talking about this, one of the things that the committee may have to entertain as we go into next school year is, or if the state allows it, given what we could potentially be facing next school year as it pertains to the coronavirus and illness and shutdowns and the processes that we've used in the district to make sure that people aren't abusing the, hey, my kid is sick, we may have to make some temporary tweaks to the attendance policy that would provide some flexibility for families, because we don't want families to, be doctored to death, if you will, where they're constantly having to run in and out of the doctor's office, even though hit certain criteria. We may also have to have policy in place that talks about what does it mean for quarantine and how does attendance get taken. For instance, if a first grade classroom, has a couple of kids who come in and end up testing positive, they have the symptoms, they cough all over their classmates, and then that classroom ends up getting quarantined. Our policy is going to have to be either waived or there has to be a level of flexibility in it, because we don't want to punish parents through the pandemic situation. I think most parents, would say that the homeschooling has been challenge enough. We don't need to add any on top of that. So
Are you and some of the administration beginning to think about how that might happen? We don't have anything now, but.
Yeah, we're looking at.
I know you've got a lot to.
We have the guidance from the state, joint DHS, DPI guidance is supposed to come to us on Monday. We began talking this afternoon about convening a committee, including a board member. We do need to wait for Mr. Como to be available. Evidently, he's out of town for a couple days. But, getting a committee together that consists of a member or two of the board, some parents, some teachers, some principals, district office staff, that considers transportation, food service, our facilities needs, cleaning, the recommendations, and spending a lot of time in July to come up with a plan that we can then present to people and get feedback in early August and make adjustments to going into the school year. But we talked to Dr. Siebert about that today, and it's very similar to what all districts are working on right now. So it's, we're taking in the guidance.
Okay.
It does make it a little bit unique that we're trying to address this county by county. Some school districts operate in 2 counties, 3 counties. Sometimes you are a near neighbor to a district in another county, and what's being recommended is not always consistent. So we're getting ready for that.
Okay, wow. Okay, anything else on the election day official piece of this?
I'd recommend that we approve the policy change to 5,200 attendance as presented on the election official opportunity for a 16 and 17-year-old.
I'll second.
Seconded by Corey. Further discussion? Seeing none, all in favor, please say aye.
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 Opposed? No? 3-0. Okay, we have some terminology on, that's my word here. Full-time student. What do we need to know here?
As our friends at the Department of Public Instruction do to us regularly, they change the names of things. And so you can see in item C that youth options has been crossed out. That's no longer a program at the state level. The two programs now are college credit program, early college credit program and the Start College Now program. So
It's just
it's a matter of terminology. There's nothing that's really changed.
And I move to accept the changes to policy 5200.01 on full-time student, recognizing the change of language from the old youth options to our current early college credit program and Start College Now program.
I'll second.
Seconded by Corey. Further discussion? All in favor, please say aye.
Aye.
3-0. And 5461. Again, some definitions in here, right?
Correct. For a long time, school districts in the state, were advocates of and put a framework out there for response to instruction, response to intervention, RTI model. And that has changed and it's become far more comprehensive and the district has really begun to do some work. I think you saw an update in the board packet this past week about our MLSS framework. And so we will be using the MLSS model to designate students who are, they'll have to have exposure to that model before we designate them as at risk of not graduating from high school. So you see that that's a language change through
This
the
is
policy.
just a terminology change also.
Correct.
But with that terminology is a program that's behind it.
There's a lot of work that's going into the MLSS framework, and then on the other end of that is the at-risk programming that we offer in the district. And so we have to formally designate students, grades 5 through 12, who are at risk of not graduating. That's the state statute. And so we use the MLSS framework to identify those kids, make sure that they've had supports along the way, make sure that they continue to get supports. But then you may, if you look at the services that are provided at East High School, for instance, or where we've put an at-risk teacher in at North, South, and West High School, kids who are at risk now are being given services, comprehensive services, starting in grade 9 instead of waiting until, they were substantially credit deficient, grades 11 and 12.
You or one of your team, I forgot it was Jason, maybe periodically comes to the T&L meetings and goes through that
Yeah,
list.
Luke does.
Luke does
Has given the overview on the at-risk
Side of it.
side of it. We do that. We try to do that to the T&L committee twice a year. I think this year we did it once. And then anytime you get an update from East, understand you're getting an update on at-risk services in the district.
Yeah. Okay.
I would move that we accept the policy changes to 5461, children at risk of not graduating from high school, incorporating the new language about the multi-level system of supports, MLSS framework.
I'll second.
Seconded by Corey. Further discussion? All in favor, please say aye. Aye.
Aye.
3-0. Then- Student harassment, 5517. This is another of our meatier ones.
Is the first change to this talks about, people who may claim harassment, but the harassment comes under the scope of bullying. And bullying has its own procedures for investigation. So we would use the bullying process to tease out if it's bullying or harassment. And so you see that in green there. The other thing that gets, if you go to item G, that starts talking about boundary invasions. And what this tries to do is provide examples, a couple of examples of where a boundary invasion may be appropriate. And that appropriateness would come in the form of, and they use the example of a football coach or a wrestling coach having to physically redirect a student or put them in a position where they know what it is that they're to do, or a kindergarten teacher who has to help a student who has a toileting accident. And so you talk about things that are appropriate within the school so that all boundary and, anything that would, come across as a boundary invasion, that people know that some things we need to do. We need to help a little kid who's had an accident at school. We always have. That's appropriate. But then it gets down into things that are boundary invasions, not limited, but they do provide a pretty substantial list
quite a
of
list.
things. And these are, I would say, would not go so far as to say these are examples from Waukesha, but these are examples that have happened in K-12 settings across the country. So it's not so far as to say that these things have not happened in school settings, and that's why they start to get into being very, very clear about, what is appropriate and what's not appropriate. We don't want to get into situations where, staff begin to groom somebody and then say, well, I wasn't doing anything wrong. I was just trying to be there for the kids. So some of this gets into that, that behavior. And then we talk about that inappropriate boundary invasions are prohibited and must be reported promptly to one of the district compliance officers as designated into the policy, the building principal, or the superintendent. So staff members who are aware of this, students who experience it, we need to make sure that we get a hold of that and we can investigate that. And if it requires us to forward it along to law enforcement or child protective services, we will do that.
Some of these, I'm looking at number 17. I don't know if you got it on there. It seems like that's a rather common thing to do, pull somebody out of a class and maybe meet with your guidance counselor or.
There'd be an appropriate reason to leave class.
Okay.
There also could be an inappropriate reason to,
That's
come down to my classroom, I have my prep period, here's a pass. The one is for a purpose, an educational purpose, a career planning purpose, even a supportive purpose. The other one could be that inappropriate grooming that may be occurring, and we want to avoid that.
So that lead sentence stops at one and allows the other. Inappropriate, okay.
Inappropriate.
Yeah, you have to think about that word when you're reading further down there. Yes.
This again being all in green and being, there's so many of these situations that I can say that I know happened, during my career. It's when is it inappropriate, when it's not inappropriate. I think this is definitely something that staff needs to be aware of. The language that's now fits in the category of being, student harassment, type of thing versus.
So
giving the kid a ride because they need a ride, type of situation, and so many other
we
things
do
here.
have processes, and we do have designated staff who can give a ride, for instance. An administrator, in the event of an emergency, an administrator or a social worker can give that ride. But again, for a staff member's protection, the idea of having a student in the vehicle it's a very risky thing from both a liability and then an accusation standpoint. And we want to make sure that that's discouraged to the greatest extent possible.
Well, and I look at 12, inviting students to the staff member's home without proper chaperones. You have kids come over for before the game, like a meeting the night before a game and have a meal or something like that. Like some of these kinds of things could end up happening, and not meant to be a harassment situation by any means.
Actually, I would like to mark this one as another one to review at the next board meeting. I mean, more than just say we've passed that one.
Your script?
We'll work on that. Yeah. Yes.
Just for your script, not for, yeah, okay.
Yes, Lynn, that's correct.
Okay.
Because I think, back to Diane's earlier point, making sure that there are people out there that are aware this is going on.
Mm-hmm.
And so, anyway.
Thank you.
My only thought is I think, I forgot the word you used, but I think your word was discouraging this type of behavior, because the first sentence says boundary invasions are either appropriate, inappropriate, then it attempts to define those, then it gives a list of 21 things that may or may not be exhaustive. I mean, this is there's a whole lot of room within those definitions and the definition of appropriate, inappropriate. But if it's meant to just basically put the employees in notice that these are potential areas of problems,
So I think
about it. But these are not in any way, shape, or form bright line rules.
no,
Oh,
I think I think
It's important.
in the mind of the person.
Yeah.
So Diane, to your example, if before the football game you had a club over to your house, or the football team went to somebody's house and you're not talking about a situation where there's malintent. But
No,
there have been
no.
situations where it's been like, would you come over to my house and help me with? And you're talking about one student or two students, and they come over to somebody's house, and then how often does that happen? And then does it turn into, and so there could be a person out there. I'm not saying that there is, but there could be a person out there that says, oh, wait a minute, now that, I was doing that, and I was doing that with a bad intention, and now I know that this is inappropriate.
Yeah.
We've outlined that. Because a lot of what you see there is grooming behavior. You start talking about, sexual jokes to students. I mean, what defines a sexual joke? And is that part of a grooming behavior? Is that those boundary invasions that start to lead to something else? And that is listed. Signs of sexual grooming is listed in that paragraph, and that's one of the things that we need to make sure we protect our students from. I'm not saying that we have staff that would do that, but if we did, we want to make sure that we put as many protections in place for students. This is a heads up to staff that, hey guys, this stuff isn't appropriate, but this is in place to protect kids.
Yeah. Good. Is there a motion on this one?
Please, I will move to approve the revisions to policy 5517, student anti-harassment, as presented.
I second the motion.
Seconded by Diane, thank you. Further discussion? Seeing none, all in favor, please say aye.
Aye.
Opposed? Got it, 2-0. Oops, I read, no. Oh my gosh. Look at what's left. Corporal punishment. 5630. Joe, we got lots of green and red on here, and it's not Christmas, so.
Yeah, and you guys can thank me for this because I pushed Neola on what they were going to do for corporal punishment a few months back, and this is what they sent back to us. So what they were trying to do in corporal punishment is to lump corporal punishment and seclusion and restraint within the same policy. And seclusion and restraint has a very clear statutory support, and it is not corporal punishment. It's something that's there and it's in place. It may be used from time to time to address dysregulated kids. Corporal punishment is, the physical, for lack of a better term, it's the physical abuse of kids in school. And so this policy addresses that. And what this does is it outlines, that you may never do it to a kid, that there are appropriate means to remove a kid from class, suspension, expulsion, or other disciplinary interventions. I mean, if the situation is bad enough, we have the ability to call the police to get their assistance if it's needed. But it also talks about what is reasonable within the scope of using force. And, for you think about a high school situation where kids are in a fight and, somebody's getting beat up in the hallway, you don't want staff to say, I can't put my hands on, when they could be in a position to act and protect the kids. So we go through that. You deal with kids, at an elementary level that may run from school while they're out on the playground. We don't want a staff member to have to sort through a whole lot of thinking before they grab that child by the arm to prevent them from running into traffic. Common sense thing. Forced to obtain the possession of a weapon. Unfortunately, we had a situation, that involved a staff member needing to respond like that. Forced to protect yourself. So it does go through and it outlines what's acceptable. But it also makes it clear that corporal punishment is against the law. And I can't think of a state right now where corporal punishment is still on the books. I do believe that there were still some states as recently as, 5 years ago that had it, but I do believe it's been removed. So the difference between corporal punishment and reasonable physical intervention is I think what this policy addresses.
I couldn't help but think as I'm reading this, the reasonable and necessary force, which is so much like a part of the language now of policing,
Right.
That's in our society. And I almost feel like we should rename it instead of corporal punishment, reasonable and necessary, behaviors.
I mean, the title.
Corporal punishment is specifically addressed in statute as being prohibited. So
That's the
I do
word.
believe that's the word. I do believe that's why Neola is stuck with the word under 118.31 in the statutes.
Okay.
Right.
Yeah, because I agree with Mrs. Voigt. Corporal punishment in the normal terminology of society is teachers striking students in forced compliance. I think what this is talking about, exactly what everybody's talking about, is preventing harm to other students, or preventing a student from harming themselves. So whether we rename it or not, I get the point. Can I address a different point? I think you mentioned seclusion. I know this doesn't deal with that. Does the district use seclusion? You mentioned restraint and seclusion.
Yeah, the district has a policy on seclusion and restraint, and that aligns with statute. That is not. I
Not this.
pushed with
Not
Neola
this.
to make sure that the two were always separate, because seclusion and restraint are completely different.
Okay. Can we deal with that in a,
Seclusion?
yeah,
You want-
seclusion.
you want to bring
Not
that-
right now, bring it for a future,
We can do that.
okay. Thank you. But with this one, I'm fine.
Yeah, we can, at least to become refreshed as to what it's about. We'll bring that up next.
Yes, sir.
Diane?
This is another one. I have no problem approving it, but I think it's one that, with all that red and green, this is a major change. I think the rest of the board needs to be at least brought to their attention.
I think we can do that. I have no problem with that.
You know, again, we can either have them
Well-
approve it, but I think it's fine. I don't feel uncomfortable approving it here. But I definitely think that they should know that it's been something that's been addressed and changed.
I have no issue with that. I have good issue with that. Okay. Seeking a motion on 5630.
I'll take the last one. I'll move to approve the revisions to policy 5630, corporal punishment, or corporal
That's it.
punishment as presented.
I second the motion.
Any further discussion? Seeing none, all in favor, please say aye.
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 3-0, Lynn? Excellent, excellent. Cooperation in getting through what was it, 80 some odd pages?
Page 86. This kind of a guide really helped me just to have that summary sheet of
Bill,
all
there
of
did-
them. And then you just check, you know.
Because the difficulty I was having is trying to scroll all the way down the policy and going back to that, so I just wrote them on here so you didn't have to make all the
Yeah,
motions.
but I just printed this out as being like the cover sheet. It just is a guide to all the, you know,
So,
because it's a lot of referencing.
Yeah, I'll do
to
that
get to
next
everything
time.
that was there. And then a few of them that I thought we should talk about, I did print out, you know, because like, yeah, there's a lot of green there that we need to be pointing out to other people.
Okay. The only other items on the agenda are, and this is, Corey, you're leading, and on this one, the recommendation for future meeting, we will engage a discussion on seclusion and how it works in our district. Is that what you meant?
Seclusion and restraint, yes, if that's one
Yeah.
policy or two.
Joe, you can prepare for that?
Yeah. yeah.
Good.
Thank you.
Any other recommendations or other as needed?
We will be getting a substantial new policy revision. I'm not quite sure what it looks like due to the Title IX changes that came out of the office of the Department of Education at the federal level. I do know that those changes are being challenged in court right now. I think there's 19 or 20 states that are suing the federal government for the changes because the policies have been described as making it prohibitive or more difficult for a victim to make a allegation of sexual harassment. So there are some states that are in the legal process with it. I don't know if that rule will be put on hold. I do know that if it's not put on hold, we have to have certain things in place by August 14th. So we will have to pursue that.
Oh, quickly.
We'll have to approve those policies. There are legal updates. We'll have to approve those policies at the July committee meeting so that we can begin doing our work for that August launch date. And that includes making sure that all staff are trained at a certain level as to what sexual harassment is, and then breaking that down into the levels of who does what, and making sure that we've got a team of investigators trained in the district so that we can follow up on complaints.
Is this, Title IX, is that adult to student?
Title IX is discrimination based off of gender, based off of sex. So it has to deal with anything that would be a
Students and adult, staff?
students, adults, visitors to our sites.
Oh, okay.
The nice thing is that the Office of Civil Rights had moved towards common investigation procedures for all of the areas of discrimination and harassment. So there was a point in time where we had the latitude to, this is what we do when we get harassment and discrimination. The new rule is so much more detailed and has so many more steps involved and layers in the organization that, Sharon and I, for instance, as compliance officers, we can't be investigators because the compliance officer can't be the investigator. We have to get the level of review, and then the superintendent is in place, and how do the complaints and the appeals even flow within the system?
Is that the kind of stuff that's being sued?
There's a lot of those changes that are in place, including, the right to, under the new rule, we have to submit all of the investigation components to the person who has been accused, including the statements and everything like that. So how do we maintain a level of protection for the victim is where a lot of the challenge is coming in.
So we are, at this point, not real sure what we'll be doing in August.
Well, I've read the rule. I know in August, there are certain steps that we have to make by August 14th.
Regardless.
And then I know the training that we need to do between August 14th and the beginning of the school year. So we have that laid out. It's just a matter of getting the actual policies in place. That is in the hands of the attorneys. The investigation, Bulow and Vetter sent me a 19-page document that, is kind of what they're generally going off of right now until they see where the final rule lands. And because it is something that is developed through the Department of Ed, with an election coming up, if there's changes at the Department of Ed, the law then could change with a new, head of, Secretary of Education, new president. So there's a lot of things around this particular case that could be in flux. I'd say the next maybe 12 months, we could make changes then that we have to go back and revert to what we used to do.
Yeah.
The one that, I'm sorry,
Oh, go ahead.
that made the news where the Trump administration restricted the avenues for reporting, and now Governor Evers is saying ignore it.
Yeah, there's the Attorney General is the one who's filing the case, but I think there's nearly 20 states or more in the country that are saying that, we have to be in a position where we're protecting victims, not protecting the accused. And a lot of people believe that this particular change protects the accused more than it does the victim. So I'm not a legal scholar on it. I'm just the person who's going to have to implement it.
Well, it looks like something interesting to see in the future too, right? All right, anything else?
Sure.
For that, the meeting will be whatever, closed.